begin?
No, not before we begin, Judge. I just placed a copy of the draft instructions. I've already found some errors that I'm going to correct before we get a discussion.
All right, just for the record, the defendant is present, has been throughout. The defense attorney is here, and the jury's on its way up. I appreciate the cover page, but it's not necessary.
Okay.
Jury ready? Bring them in.
Every time I've been talk, Your Honor.
Thank you.
Jury's all present and seated, Your Honor.
Thank you. Everybody able to get lunch and follow my instructions?
Yes.
Excellent. State, call your next witness.
So we call Salvatore Pizzo.
Good afternoon, sir. If you can step up to the podium right here. Stop right there. Raise your right hand and be sworn by this oath.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, sir, please have a seat in the witness stand over here and speak in a loud and clear voice for me, okay? Thank you, sir. State, you may proceed.
Thank you, Judge. Could you please introduce yourself to the jury?
Salvatore Pizzo,
And how do you spell your last name?
P-I-Z-Z-O.
Mr. Pizzo, I want to take you back to September of 2014. What were you doing for work at that time?
Driving for Joe's car service.
Okay, and what kind of work is that?
It's like picking up people like a taxi cab.
Okay, so would I be wrong if I refer to you as a taxi driver?
No,
Were you working the night of September 4th of 2014?
yes,
And did you have occasion to pick somebody up from the area of Yachtsman and Bertrand?
yes,
And was that about between 10:30 at night and 11 o'clock at night?
yes.
Can you describe, was it one person or more than one person?
More than one person.
And what was their basic description? Women, men, adults, children?
One adult and one child, but between 4 and 5.
And gender?
Male,
Both
both
of them?
males.
And when you picked the person up, did that person introduce himself?
Yes,
What did he say his name was?
Jake.
And now, Bertrand and Yachtsman, is that back in a neighborhood somewhere?
It's off of Old Dixie Highway.
And in order to get back out to the main roads, do you have to go down Yachtsman to Old Dixie Highway?
Yes,
And when you do that, and you turn on Old Dixie Highway, did you notice anything going on just a little bit north of Yachtsman?
yes.
What did you see?
Bunch of policemen looking for something or doing something in the area, general area.
Was it hard to miss?
No,
Was it impossible to miss?
no,
Not impossible to miss?
no, you can't miss it at all.
Okay, you can't miss it at all.
Right.
Did you say anything about that as you were passing by with this?
All I
with these people?
said, I told him that there's something going on over here. I don't know what it is, and he didn't seem like worried about it.
Yeah, didn't say anything, didn't respond at all?
No,
Didn't mention that it was his house that they were at?
no.
Okay.
Overruled.
And where did the person want to go?
He said Port Myers or Key West.
Where did he want you to take it?
Oh, you want me to take him to the bus station, Greyhound, Tampa?
Okay. What route do you take to get there?
I took Yachtsman to Old Dixie Highway, took Old Dixie Highway to Hudson Avenue to 5A, 5A to Little Road to 52, and 52 to Veterans Expressway.
Okay, and stop right there. We'll go back to the route in a minute, but were there any stops that you made along
Yes.
that route? Where
Yes.
you stop?
Circle K at Moon Lake and 52.
Okay, and did your customer want to stop someplace to get something?
Yes, he wanted a drink for his son because his son was looking at my drink and he was thirsty. So he said, "Oh, you can stop at the store and get him a drink."
Okay, and if I can draw your attention to that big screen right there. All right, Ms. so, I want to draw your attention to this surveillance video. I have it paused right now. In particular, there's a white or silver vehicle over here. Do you recognize that vehicle?
Yes, that's the car I was driving with Joe's taxi.
And who's this guy right here?
Me waiting on him.
Okay, and these two individuals here, are those the people you picked up?
Yes, sir.
Now, after Circle K, so you're telling us you go down 52 to the Veterans Expressway, where do you go from there?
From Bennett Expressway over towards 275, take 275 over to the Greyhound bus station.
Okay. And did you, in fact, drop this person off at the Greyhound bus station?
Yes, I did.
Did he pay you?
Yes,
How did he pay you?
cash.
Approximately how much?
About 120.
Okay. And about how long did the trip take you?
And we're between, there was a lot of traffic that night, and we're between an hour to hour and a half.
Okay. And you dropped him off at the bus stop, and that's the last you ever see the guy?
Yes,
Shortly thereafter, did law enforcement come into contact with you about this particular cab fare?
they got in contact with the company, and he says, did anybody pick up a gentleman with a little small boy? And I got back on the radio, and it says, I did. And he says, call me on the phone, and he goes, well, there's an officer on his en route.
And we don't need to go into all the details, but because I can't go into what people said. But did you ultimately meet with law enforcement about that?
Yes, I did.
Okay. And did they ask you questions about it?
Yes, they did.
And did you answer their questions?
Yes, I did.
All right, Judge, if I can have just a moment.
You may.
I have no more questions, Judge.
Cross?
Good afternoon, sir.
Good afternoon.
The little boy, did he seem in good health?
Hmm?
He seemed in good health, the little
Oh,
boy?
yes, he did.
Did this look like a normal customer to you at the time?
A normal customer?
A normal customer? Did he seem like a normal customer at the time?
Yes, he just seemed like normal, like, like anybody I picked up from normal cab fare.
Okay. Was he polite?
Yes, he was.
And did he give you a tip?
Yes,
And your cab fare was $82, right?
$80.
And he gave you 120?
Yes,
So it's about 50% tip, right?
yes.
Thank you, sir.
Any redirect?
I don't have any questions, sir.
Are you releasing him from his subpoena?
Yes, Judge.
Defense, any objection to release?
There you go.
Sir, you may step down and you're free to go.
Thank you.
very much.
Have a good day.
State, call your next witness.
Do you ever call Detective Mike Rosa? Or, I'm sorry, Sergeant Mike Rosa.
Good afternoon, Sergeant. You want to step to the podium?
Yes, ma'am.
Raise your right hand. Be sworn by my clerk.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you may have a seat in the witness stand and speak in a loud and clear voice for me.
Thank you.
State, you may proceed.
Thank you, Judge. Could you please turn and introduce yourself to the jury?
Hello, jury. My name is Michael Alexander Rosa. I'm currently a sergeant with the Pasco County Sheriff's Office.
And what are your duties with the Sheriff's Office currently?
I'm currently a sergeant with the Major Crimes Unit of the Pasco Sheriff's Office.
So are you acquainted with what the Major Crimes Unit does?
Yes. We work all kinds of cases from homicides to child abuses to rapes to robberies.
Now, back in September of 2014, what was your position?
I was a detective with the Major Crimes Unit.
And were you involved in the investigation regarding the 4 homicides that occurred in the area of 7719 Hatters Drive and Old Dixie Highway?
I was, sir.
How would you describe your involvement?
I assisted in interviewing and showing photo packs and also assisted in following up with the defendant's call log.
Okay. In particular, September 4th, 2014, fair to say that you guys initially, when you get out there, didn't know exactly what was going on.
That's fair to say, sir.
And gradually, as the investigation progresses and you find things and find bodies that you're starting to get a clearer picture.
Yes, sir.
Was your involvement at that early stage, September 4th, going into September 5th of 2014, did you track down some Papa John's delivery drivers?
I did.
And was one of those Jesse Fletcher?
Yes, sir.
And did you speak with Jesse Fletcher?
I did.
And did you ask him questions?
I did.
And did he cooperate with you?
Yes.
I want to show you, Judge, may I approach the witness?
You may.
I want to show you what's been entered into evidence as State's Exhibit 610. Go ahead and look at that. Have you seen that before?
I have.
And can you tell the jury what is that?
This is a photo pack.
And can you describe for the jury what a photo pack is and why it is used?
A photo pack is used to identify subjects involved in an investigation. It could be identify witnesses, victims, but usually it's used to identify suspects.
Okay. And when you present somebody with a photo pack, how do you go about doing it?
I set up an appointment. I meet the person at their location. The photo pack is presented. I first read the instructions to them. Then I have the person I'm presenting the photo pack to read the instructions as well, and they initial that they understand. I shuffle the photos, and I do not know the order of the photos at that time. And then I show the photo pack to the person I'm showing it to them. I usually explain to them that the person may or may not be in the photo pack as well.
Okay. And in addition to, how many photographs are there within the photo pack?
There is 6.
In addition to those 6 photographs, are there also a couple blank pages that get shuffled in as well?
There is.
And that's the procedure?
Yes, sir.
So that way, if people are thumbing through and they see a blank page, they know why.
Yes.
Now, with Mr. Fletcher, did you go through that procedure that you just outlined for the jury and read the instructions that are contained on the photo pack with him?
I did. And
did he look through the photo pack?
He did.
Do you remember the date and time that you actually presented it to him?
It's noted on here. I would have to look, but I would have to look at the photo pack.
Would that refresh your recollection?
It would.
Then please go ahead and look at that.
The photo pack was presented on September 5th, 2014 at 2 minutes past midnight.
Okay, so we're just going into September 5th when you presented this photo pack.
Yes, sir.
All right. And was he able to identify the person that he had delivered pizza to on September 2nd within that photo pack?
He did.
And can you thumb through there and tell us who he selected?
He selected photo number 7, the defendant, Mr.
Now,
Matos.
The person that is pictured in photo number 7, do you see that person in the courtroom here today?
I do.
Could you please point him out and identify something he's wearing?
He is directly to my left. I think it's a blue polka dot tie and a white shirt.
Judge, may the record reflect the witness has indicated the defendant.
It will so reflect.
Now, subsequent to getting in touch with Mr. Fletcher and presenting him the photo pack, did you also come into contact with an Erin Jacobs?
I did, sir.
And did you meet up with her?
I did.
And did you ask her questions?
I did.
Did she cooperate with you?
Absolutely, sir.
I'm showing you state 600. Have you seen that before?
I have.
And did you go through the same procedure with Ms. Jacobs that you've already indicated you went through with Mr. Fletcher?
I did.
Now, did Ms. Jacobs, was Ms. Jacobs able to identify the person within the photo pack?
She was not.
What did she say when she went through the photo pack?
Objection, hearsay.
Approach.
What did Ms. Jacobs say in reference to an identification with regard to that photo pack?
She was not positive. She told me that there was between 2 different photos.
And which 2 photographs were those?
I have to look at my report if you don't mind, sir. I believe it's photo number 2 and number 7.
All right, if you need to refresh your recollection, please go ahead and do so.
Thank you. Yes, sir. Photo number 2 and photo number 7.
And if you could look, thumb through that photo pack real quick for me and look at page number 7.
Yes, sir.
Do you recognize that photograph?
I do.
Who is that of?
Mr. Matos, the defendant.
Okay. Now, in addition to tracking down the Papa John's people, did you also attempt to track down 10 or so bags of garbage that had been removed from 7719 Hatteras Drive by the trash collector?
I did.
Did you go speak with the garbage men, for lack of a better term?
Yes, sir.
And did you speak with the company to try and locate these bags?
I did.
And did you find those bags?
I did not.
And why not?
The bags were collected by the garbage company. I'm not sure the name at this time. And the bag was told by the company that the bags are taken from that location and destroyed, immediately destroyed.
Now, had you been able to find those, if they hadn't been destroyed, would you have gone through them?
Absolutely, sir.
Were you also involved, well, let me ask it this way. Do you know what a neighborhood check is?
I do.
What is a neighborhood check?
A neighborhood check is done to possibly find witnesses to a crime in the area. We usually interview people in the area, the homes around the possible crime scene, the streets around there. We interview anybody that we can locate, people walking their dogs, people at their houses, neighbor businesses. We're looking for witnesses, looking for surveillance video. We're looking for anything that may help with the investigation.
And was a neighborhood check done with regard to this investigation?
Yes, sir.
Did you participate in that?
I did.
Were you the only one who was participating in that?
No, sir. Several detectives assisted.
What areas did you specifically do a neighborhood check in?
On Hatteras Street and one house on Almond,
Okay, and Almond would be the street across the canal from Hatteras?
just west of Hatteras.
So, for example, if I was to take a canoe from the dead end of Hatteras and go straight to the next street over, I'd be at Almond?
That is correct, sir.
Okay. And while doing your neighborhood check, did you also make contact with Mr. Lusk?
I did.
And did Mr. Lusk cooperate with you
He did.
and provide you with information?
He did.
In addition to doing a neighborhood check, did you end up going through phone records for a phone number of 484-951-2687?
Yes, sir.
And particularly, did you have dates that you were interested in with regards to those phone records?
Yes, sir.
Were those dates between August 28, 2014 and September 4th of 2014?
Yes, sir.
And what did you do with regard to those phone records?
I was looking through to see who the defendant contacted and who contacted him.
Okay. And as you see those, did you do anything with your investigation with regard to those numbers that appeared on the phone record?
Yep, I spoke to several people and I discovered that the defendant was selling property on Craigslist.
Now, were you the only detective involved in calling the numbers on the phone list?
No, sir.
So there was somebody else helping you with that?
Yes.
How many different, well, let me start this way. Did you make contact with a Patrick Duarte?
I did.
And did you speak with him on the phone first?
I did.
So after speaking with him on the phone, did you decide you wanted to go out and meet with him?
I did.
Did you drive out to the Orlando area where he was to do that?
Yes, sir.
And did you sit down and speak with him about what he might know about the case out there?
I did.
Were you the only detective involved in doing that?
No, sir.
And did Mr. Duarte let you take his phone and download information off of it?
Yes, sir.
And what was the purpose of that?
There were several text messages corresponding with Mr. Matos that we wanted to forensically download.
Okay, so they could be preserved?
Yes, sir.
And was that done?
Yes, sir.
Now, when you were speaking with Mr. Duarte, did you present him with a photo pack?
I did not.
Why did you not present him with a photo pack?
During this investigation, Mr. Duarte advised me that he had seen this incident on the news and online as well.
All right, and were you aware of the news coverage?
I was.
And were you aware that the defendant was prominently featured in all the news coverage in terms of a photograph of him?
I was aware of that.
And did Mr. Duarte identify the person being pictured by the news as the person that he had dealt with?
Yes, sir.
Did you also make contact with Paige Steele based off of the phone records?
I did.
And did you go out to see Miss Steele?
I did.
And I'm going to show you what's been entered into evidence of States 597. Have you seen this before?
I have.
And what is that?
It is a photo pack.
And did you present that to Miss Steele?
I did.
Did you present it using the same method that you've already described for the jury, reading her the instructions, telling her that the person may or may not be in the photo pack, shuffling the papers and all of that stuff?
Yes, sir.
And once you did that, was she able to make an identification?
She was.
And who did she pick out in the photo pack?
She picked out photo number 4,
And who is photo number 4 of?
the defendant, Mr. Matos.
Okay. And I'm sorry, what was the date and time that you made contact with Ms. Steele?
Again, I'll have to look if that's okay, sir.
Sure, if that would refresh your recollection.
It would. September 8th, 2014 at 17:49 hours, so 5:49 p.m.
All right, I want to show you States Exhibit 594. Did you make contact with James Smith as part of your investigation?
I did.
And was Mr. Smith's situation a little different in that he actually contacted the sheriff's office first?
Yes, sir.
And did you go out and just speak with him?
I did.
And did he cooperate with you?
He did.
Did he answer your questions?
Yes, sir.
And that item, I think it was 597. 594. Can you tell us what that is?
It's a photo pack, sir.
And did you present it to Mr. Smith using the same manner and method that you've already described?
I did.
And was Mr. Smith able to make a selection out of that photo pack?
He did.
And who did he select in the photo pack?
He selected photo number 2, the defendant, Mr. Matos.
Okay. And based on speaking with Mr. Smith, did you learn that you might want to speak with a Brandon Derry?
I did.
And did you have occasion to speak with Brandon Derry?
I did.
And I'm showing you States 595. Did Mr. Derry cooperate with you?
He did.
Did he answer your questions?
He did.
And States 595, have you seen that before?
I have.
What is it?
It's a photo pack.
And did you present that photo pack to Mr. Derry?
I did.
Now, when you're presenting these photo packs, do you do it to people individually or in a group?
Individually.
Okay, and did you do that with all the people that you presented photo packs to in this case?
I did.
So Mr. Derry, was he able to make an identification of the person that they had dealt with on August 29th in regards to a TV?
He did.
And who did he select in the photo pack?
He selected photo number 3, Mr. Matos, the defendant.
Okay. One of the numbers that you called from the phone records that we've been referencing, did you get Pizza Hut?
I did.
Based on that, did you do some investigation into the Pizza Hut to determine if they had any relevant information or if there were any witnesses?
Yes, sir, I did.
And based on your investigation, did you locate a Michael Hall?
I did.
And did you go out and did you speak with Michael Hall?
I did.
And did he answer your questions?
He did.
Did he cooperate with you?
Yes, sir.
And I'm going to show you States 598. Have you seen this before?
Yes, sir, I have.
And what is that?
It's also a photo pack.
Is that the photo pack that you presented to Mr. Hall?
It is.
And did you go about presenting it to him using the same method and manner that you already described, where you read him the instructions, told him the person may or may not be in the photo pack, shuffled the papers, those sorts of things?
Yes, sir.
And was he able to select the person that he delivered pizza to the afternoon of August 29th of 2014?
He did.
And who did he select?
He selected photo number 5, the defendant, Mr. Matos.
Okay. Now, in addition to those people that we've just discussed, when you were going through calling numbers on the phone list, did you also talk to a Gary Morris, an Alexia McAllister, a Toshi Rump, a Carol Shu Mulheron, a Michael Pelletier, and a Jose Castro?
I did.
And did they all appear to be Craigslist buyers?
Yes.
Did you go out and speak with all of them?
I did not.
And why not?
Several of them did not make contact with the defendant. It was just all by phone. I made contact with several people that did because either they had text messages or they actually were face-to-face.
Okay, and so those people were people that you didn't, it was your impression that they would have never gone to the house or had contact with the people in the house, is that what
Correct.
you're saying? Did some of them have text messages, though, that you still went and recovered?
Yes, me or another detective did.
Okay. Now, as you're gathering all of this information, do you relay this information to the other detectives that are involved in the case, particularly Detective Kugel and Detective Kennedy?
I did.
So, as you're gathering information, Detective Kennedy and Detective Kugel are also getting that information.
Correct.
Judge, may I have a moment?
You may.
I don't have any more questions, Judge.
Cross?
Yes, Your Honor. Good afternoon, Detective Rosa.
Good afternoon, sir.
When you did subpoena records request for Adam Matos' phone number, you did so for other numbers as well, correct?
I actually am not the person who subpoenaed him. Another detective did. I just went over the records when we retained information back.
Are you familiar with the other numbers that were researched?
As in on the defendant's record or other
Do you know
numbers?
what cell phone was linked to Nicholas Leonard's cell phone?
I do not.
Do you have that in your report?
I don't believe so, sir.
How about Megan Brown's cell phone? Do you know?
I had their numbers, but I was only going over the defendant's records.
Okay, but you know that those records were received by your office, correct?
Yes, but not reviewed by me, sir.
Thank you, sir. I have
You're
no further
welcome.
questions.
Any redirect? All right, Sergeant, thank you very much. You may step down. Is he released from the subpoena?
Yes, sir.
All right. Spence, any objection?
No, Your Honor.
Free to go.
Thank you, ma'am.
Sergeant.
Thank you.
State, call your next witness.
Jerry Lamanna.
Good afternoon, ma'am. Can you step to the podium for me? Longest cutest dog I've ever seen. All right, if you can raise your right hand and be sworn by my clerk.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, please have a seat in the witness stand. And speak in a loud and clear voice. State, you may proceed.
Thank you, Judge. Good afternoon.
Good afternoon.
Would you please introduce yourself to the jury?
My name's Jerry Lamanna.
And will you spell your first and last name for the court reporter?
Is Jerillamana.
And Ms. Lamanna, what do you do for a living?
I train dogs and take care of dogs for a living.
And the dog you have here today, is that one you're currently training?
Yes.
And
Well,
what is-
she's trained, yes.
What is her name?
That's Natalie Louise Lamanna.
And Ms. Milano, where do you live?
I live on 7424 Gulf Way.
And is that the same place you lived in August and September of 2014?
Yes, sir.
Your Honor, may I approach the witness with what's been entered into evidence of States 256?
You may.
Can you give us a general idea for where your house is on this map? This is Old Dixie Highway right through here, just to help you
Okay.
orient.
So, oh. Wait,
Right at the end of,
yeah.
right at the end of this street, but not quite pictured on the
Yeah,
map.
right here.
Okay. So your house is right down this road in this general vicinity.
Yes.
Now, on September 3rd, 2014, did you go anywhere on, down Old Dixie Highway?
Yes.
Could you tell us about that?
Well, every morning, me and my best friend run our dogs, and she lives right here, right across the water from me.
What's your best friend's name?
Sherry Man,
Okay.
or Sharon Man. So I had picked her up on my off-road vehicle. I have a Rhino. It's like a side-by-side. So we rode together, picked up all the dogs, and then we took them down towards the end of Old Dixie Highway. And it used to be a dirt road then. So we normally would let the dogs just run. Actually, we did let them run that day, but we had smelled something along the way, and they started going crazy, and so we loaded them all up. And we went down and we turned around.
And when you say you smelled something, about how far down Old Dixie Highway were you when you could smell this?
Well, it was pretty early in the morning, and I would say that it was about halfway between my street and where the crime scene was. So
But where the
about
where-
3/4 of a mile, I would say.
Where the road ended, is that what you mean by the crime scene?
Yeah, where
Okay.
the road ended, where the bodies were.
And you said where the bodies were found, just so we know.
Where the bodies were found,
And would
yeah.
you kind of point on the map, is it up near that red star?
So, yes.
That's where the road ended?
Yes, they had, at that time, they were doing construction down there, so they had a barrier built there, so you couldn't get over it. I mean, some people did, but you weren't supposed to go past it. And then, so there was big, piles of dirt there.
And now, about how far down the road between your street and where the berm was, did you start to smell the odor?
I'm gonna say about halfway. I would say about in this area, and because we had already dropped the dogs right around here, I think. And it's all just coming back to me because it's been a couple years, but we had dropped him and then we picked him back up because they started going crazy and we smelled it and they smelled it. And so we had picked him up, but we went down, turned around, and it smelled so bad that we got out of there. But
And
then,
was it a smell that you were familiar with?
I've never smelled that before.
Okay. And was it a good smell?
It's not a good smell. It'll be a smell I'll never forget.
And at that point, you ended up turning around and going back home?
We turned around and, yeah, we went to the other side of the neighborhood because we knew something was definitely not what we wanted our dogs to get into down there. Yeah, it didn't really cross either of our minds that it could be, what it was.
Right.
But we thanked God that we didn't find it.
Now, you train dogs, and
Yes.
have you ever bought or sold dogs, either one?
I have purchased dogs before.
And do you have any experience with very small dogs like Yorkies?
Yes, plenty.
And what is your experience with those animals?
Well, I have plenty of clients that have them. I have lots of friends that have them, and then I grew up with them as a child.
And have you ever priced those animals?
Yes.
And what do they normally sell for?
You're gonna go anywhere between $5,000 and $2,000, and the higher end is because of the bloodlines, more show dogs. People are paying for their ancestors.
When you say 5, you mean 500?
500, yeah.
2,000?
500 would be like the lowest end of a pet.
Okay. May I have just one moment, Judge?
Okay.
We have no further questions.
Ross?
No questions,
She is.
Dennis, any objection? Ma'am, you're free to go.
Thank you. Let's do it.
Excellently behaved dog.
Oh, thank you.
State, call your next witness. Yes? I'll start with the bad news first. That is, you have to go back tomorrow, as bad as that is. But the good news is, we're done for today. We have used all the witnesses that are available today. We had one that was not able to arrive within a time period that I felt like was to wait. So, but the state indicates that all the rest of the witnesses will be going for a good long time tomorrow, and we're right on schedule. So this early dismissal today is not affecting our timing of the trial. So I'm going to go ahead and let you put your stuff away. It's a beautiful day outside, and it's time to go take a walk at lunch, and you get it all to yourself. So tomorrow, jury pool room, like normal, because they've already picked all the juries for today, so you guys get the jury pool room again tomorrow, 9:30, and we'll bring you up right away, and we'll have a big, strong day tomorrow, all right? No talking, tweeting, texting, we're not done yet, and you all have a nice afternoon. All right. This gives me time to work on some things with the lawyers anyway, so it's good for us.
Juries have the presence of the court, Your Honor.
Thank you. All right, we have some jury instructions to go over. Defense, did you get a copy of these?
We did, Judge.
All right, so we can use this time to go over the jury instructions. Now, this is only instructions for first phase, and it'll stay that way until we have to go over second phase if necessary. So we're only going over the first phase instructions. Most of these are standard. I know I asked this defense earlier, and I don't know if you were in here. They do want the self-defense instruction. Is it in here?
No, Judge, there's too many choices and decisions that have to be made as to what, so if they provide it to me in a Word document, I'll be happy to put it in. I don't feel comfortable making the choices of what for the crime being put against him and those types of, so.
I would assume you want justifiable use of deadly force, first of all, which is 3.6F.
Yes, sir.
So what I'm going to ask is tomorrow morning if you could prepare, if the defense could prepare their self-defense instruction, justifiable use of deadly force. You can prepare one that is what you would wish to have in there. Oh, you already have one?
No, I have a different proposed instruction.
What, a proposed instruction?
Yes, ma'am.
Okay, on another issue?
Yes.
Okay, so the self-defense instruction for deadly force, use of deadly force is kind of long, and there's some subparts about dwelling and residence and those kinds of things. So at this point, the defense, if you wish to have that, just prepare one that you think would meet your needs and bring it in tomorrow and we can discuss it, okay? So we can go over it and put it in with these instructions that we'll go over today. So. We'll go through the ones that they have in front of me right now. Most of these are standard. Up there. First and foremost, I don't know, when we have a homicide, I usually start with introduction of homicide before I go introduction of final instructions, but it doesn't matter to me. One half doesn't the other as far as I'm concerned. So if anybody have a problem with, and by the way, there's no need for page numbers either, but
It was just helping, I can take them out, if,
It was helping you get them organized.
yeah, if they reference a page, I can make sure
Okay.
it's the right page.
So it's introduction to final instructions, members of the jury. I thank you for your attention during the trial. Please pay attention to the instructions I'm about to give you. And then Adam Matos, the defendant in this case, has been accused of the crimes of murder in the first degree, count 1, murder in the first degree, count 2, count 3, count 4. So any objection to that?
No.
Okay, and then we get into introduction to homicide, which is 7.1. I don't need the numbers on them, I'm just referencing them for that. And looks to be standard in this case. Adam Matos is accused of 4 counts of murder in the first degree. And then we have murder in the first degree includes lesser crimes with murder in the second degree and manslaughter, both which are unlawful.
Judge, I have an issue with the, I guess it's the 4th paragraph there. It's a little confusing.
I agree.
It seems to, like, all or nothing type thing. I think it needs to be,
Laid out each one individually?
yes.
Okay.
So, yeah, I agree, Judge. This is one of those paragraphs that I kind of just mismatched quickly to just get it in there.
Well, the problem, I mean, normally it's not a problem, but in this particular case, there may be different defenses as to each individual victim and different arguments about whether the state has met its burden as to whether it's first degree, second degree manslaughter, or self-defense. So I assume what the defense is asking for is that this paragraph be 4 times in a row.
Or expanded in some way to make it
Well,
clear.
I don't know how you.
I don't know exactly how to do it at the moment.
Right now it reads, I mean, the standard instruction says, if you find victim was killed by defendant, and we're supposed to fill in the blanks, you will then consider the circumstances surrounding the killing in deciding if the killing was first degree murder, or it was second degree murder, or it was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Now, I could say, if you find, and the way they have it is Nicholas Leonard, Megan Brown, Gregory Brown, and Margaret Brown was killed by Adam Matos, you will then consider the circumstances surrounding each individual killing.
Or I could put it just, I could do each paragraph 4 times, because I think that was my initial thought, because then we're sticking with the, but I would defer to the defense. It clearly needs to be corrected.
So, I mean, this is a thought, I'm not saying you have to agree to this, but to not make it 4 paragraphs, which the defense may not want that either, I could say, or it could read, if you find, and then the 4 names, was killed by Adam Matos, you will then consider the circumstances surrounding each individual killing in deciding if each individual killing was murder in the first degree, or was murder in the second degree, manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force in each case. Or I can have it 4 times. That's, what do you think?
I think instead of the 4 paragraphs to each.
You want to use all 4 paragraphs?
No, the other option. Your
Okay. So I'll reread it so the state will get it down.
I've got it.
Okay, so it'll be surrounding each individual killing in deciding if each individual killing was, and then at the end, in each case. So we're telling them 3 times, this is individual, individual, individual. So it depends, with those additions, you think you would be okay with that?
Yes.
Okay, so we'll put that in. In justifiable homicide, the next paragraph says, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. You're fine with that? That doesn't need to be separated, that's just kind of a overall, that's excusable. justifiable, and then there's excusable. And again, neither one of these paragraphs has any one of the victims or the defendant's name in it, so it's just more of a definitional paragraph. So, under excusable, again, the killing was of a human being is excusable and therefore lawful under any one of the following three circumstances, whether it was done, accident, misfortune, sudden provocation, when the killing is committed by accident or misfortune from sudden combat. So that's the standard. Any objection to the excusable standard? And then the definition of dangerous weapon is any weapon that takes into account the manner in which it is used and is likely to produce death or great bodily harm. And then the last paragraph is, I now instruct you on circumstances that must be proved before Adam Matos may be found guilty of murder in the first degree or any lesser included crime. Now, the question is, do we want to say in each case, just so we keep the theme going, or do you want to just say, have it?
I would defer to the defense.
That's going to be a standard answer, by the way.
I get the impression.
I mean, we don't have to, it's just a general definition saying I instruct you on circumstances that must be proved before Adam Matos may be found guilty of any of the murder, any of the counts of murder in first degree, or any lesser included crimes. I'm just saying, we might want to
I think any is a good idea.
Okay. So it would be, I now instruct you on the circumstances that must be proved before Adam Matos may be found guilty of any murder in the first degree or any lesser included crime. And then count one. Now these, I assume you have four count ones, and then four lessers, right? So count one would be to prove the crime of murder in the first degree. The state must prove the following three elements beyond a reasonable doubt. Nicholas Leonard is dead. The death was caused by Adam Matos, and there was a premeditated killing of Nicholas Leonard, and then all the standard wording from that. This is a standard instruction with the victim and defendant in there. Any objection to that? No. And then, of course, count two, we have Megan Brown as the victim. Same instruction. Now, on the two that were killed with a firearm, the state has alleged in count two, if you have a reasonable doubt whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of murder in the first degree. And then they had the aggravation of a felony by carrying a firearm.
That's the reclassification.
So what?
For
Really, really light? Really, really dead?
judge, in case there's a directed verdict later, or we've alleged the reclassification, so I put it in there.
Yeah, I see the box. Okay, so they want the reclassification because they did put the 1020 light wording in the indictment. So they have the wording for aggravation of felony by carrying a firearm, discharge, and discharge causing death.
I have a suggestion as it relates to the possession of a firearm, if the defense would agree. There are a total of 1, 2, 3, the first three paragraphs. I would believe it to be sufficient if it were to say, basically, if you find that Adam Matos committed murder in the first degree, and you also find beyond a reasonable doubt that during the commission of the crime, he possessed and discharged a firearm, and in doing so caused the death of Megan Brown. And then that the interrogatory question on the verdict form indicated possession, discharge, and death, and that it would be sufficient, and you would not have to read the other two paragraphs.
Ben?
Backing up a little bit, I have a problem with the use of the word aggravation, especially in this case, because it's not a legal aggravator and it's liable to be misconstrued as such.
It is actually an aggravator of a crime, but I understand his objection.
Well,
That's a
if
stock
we did it the way that he's requesting, the wording says possession of a firearm, discharge causing great bodily death. So if you put it all in one, we can actually title it like the second paragraph instead of the first, and then aggravation isn't in there.
Well, we can just call it possession, okay.
See?
Okay.
So you take out aggravation of a firearm by carrying aggravation of a felony by carrying a firearm. That wording comes out. Then you put the paragraph together like you requested with the definition of firearm, and then we just title it possession of a firearm and discharge great bodily death. Great, I think it's supposed to be great bodily harm and death, but
I took out, there's death. I can combine it, is what I'm trying to say. I think you can legally do that, and make it easier for the court to read.
I don't disagree with you, and then you title it possession of a firearm and discharge causing great bodily harm or death, or great death. I don't know how you phrase that, but.
Well, maybe the court, allow me to try to clarify my position was that under possession of a firearm, there are 3 paragraphs. And like I said, I could combine that into 1 paragraph. The court is suggesting combining aggravation of a felony where it's carried, displayed, used, threatened to use, or attempted to use, as well into that so that it's just 1 paragraph that kind of outlines the whole thing.
Right.
I don't have a problem with that as long as the interrogatories allow for carried, used, displayed, threatened to use, and then possession leading to discharge, leading to death. So that would be my, as long as there's the.
I don't want to, that's 2 different questions. The interrogatory is the interrogatory. It is what it is. It's just as whether the jury understands that the state is asking them that in the 2 cases in which a firearm was used, that they're to make a further finding that a firearm was used, it was possessed, and the discharge caused death. So the way you wanted to read this is if you find that Adam Matos committed murder in the 1st degree, and you also find beyond a reasonable doubt during the commission of the crime, he personally carried, displayed, used, threatened to use, attempted to use a firearm, you should find him guilty of murder in the 1st degree with a firearm. Then it defines firearm. If you find that Adam Matos committed murder in the 1st degree, but you were also not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened or used, or attempted to use a firearm, then you should find him guilty only of murder in the 1st degree. If you find that he committed murder in the 1st degree, you also find beyond a reasonable doubt during the commission of the crime, he discharged the firearm. So it flows just fine if we just make it one group with and we head it, possession of a firearm, discharge causing great death, and then we take the 3 paragraphs and combine them into one. I don't like that.
Great.
I just think causing death.
Yeah.
Take out great.
Where's great?
Look at your paragraph. Possession of a firearm, discharge.
Oh,
causing
my bad.
And then that explains the entire group, and then the paragraph would be, if you find Adam Matos committed murder in the 1st degree, and you also find beyond a reasonable doubt that during the commission of the crime, where do you want to put?
I would just say he possessed and discharged a firearm.
You want it and, or you want it possessed and discharged?
That's what I was.
Or do you want it and or?
Possessed and discharged.
Okay. Defense, any objection?
No.
No.
So, and we're already defining firearms in the
Take it out.
paragraph, so we can take the new definition out there. And then the question is, we still need the bottom which says actual possession.
Yep.
So we combine those three paragraphs into one. We get rid of the second definition of a firearm. We still have actual possession definition, and the whole thing's title will be possession of a firearm and discharge causing death. And the aggravation of a felony wording is gone.
Yep.
Is that good?
And just so the record, I will do, this instruction appears on count 2 and count 3.
Right.
And then the lessers to count 2 and to count 3. I will take note and I will do that on all of them and bring it back to the court tomorrow, so we don't have to go through that later on.
That's fine. So this is going to be as charged, this aggravation. It's also going to be an aggravation as to a lesser of felony murder, second degree. It's not a lesser to manslaughter.
Although the reclassification is.
Right, but not the whole thing.
Correct.
Just the possess the firearm?
No, carried, used, threatened to use, displayed to use, or attempted to use.
The first part. Yes, okay, so it just gets the first part for the manslaughter. So then on third degree murder, we have the exact same situation because with Gregory Brown, you also alleged firearm, so we do the
Yes,
aggravation paragraph the same way.
yes.
And we have the lessers of second degree murder with this enhancement, and then manslaughter just with the part about possessing, using, attempting to use, blah, blah, blah.
Yes.
Okay. On count 4, that's Margaret Brown. That's the same as count 1 on like Nicholas Leonard.
Yes. There is a correction on page 14, I already see it.
What's the correction?
It was, I left in him and her.
Mm-hmm.
I
So
took
it'd be
that
her.
out. No, him.
No,
Him.
this is Margaret
Yeah,
Brown.
but it's him, Matos.
Oh, him, okay, sorry. Not find him guilty of first degree, yes. All right, so everybody agrees to those 4, and then, again, we're talking about the lessers, and he broke them down by counts. Count 1 will be, all 4 have murder in the second degree and manslaughter as lessers. Is the defense asking for any other lessers other than that?
No.
So that will be it. Those will be the lessers, and we just went over that. Second degree murder, to prove the crime of murder in the second degree, state must prove the following 3 elements. Nicholas Leonard's dead. The death was caused by the defendant. There was an unlawful killing of Nicholas Leonard by an act imminently dangerous to another and demonstrating a deprived mind without regard to human life. Definition of act. Definition of imminently dangerous to another. In order to convict of second-degree murder, it's not necessary for the state to prove the defendant intended to cause the death. Then the part where he did not have a deprived mind without regard to human life because he acted in the heat of passion. I assume you guys want that? All right. So that's yes, based on adequate provocation, in order to find the defendant did not have a deprived mind without regard for human life because he acted in the heat of passion based on provocation. There must be a sudden event. A reasonable person would have lost normal self-control. There's not a reasonable amount of time to cool off. A reasonable person would not have cooled off, and that Adam Matos was in fact so provoked and did not cool off before he committed the act. If you have a reasonable doubt as whether he had a deprived mind without regard to human life because he acted in the heat of passion on an adequate provocation, you should find him not guilty. you should not find him guilty of murder in the second degree. I've never liked that wording, but that's the way it is. I gotta make sure I read it verbatim. Lesser as to count includes manslaughter, count 1. So these are the lessers.
So what I did is, Judge, I put the lessers as a count 1 together and not separated by a page. I can do that. I just, as I was doing it, I just thought it's already so long. But, and I have not edited the manslaughter instruction.
Oh, I see. You just kept going.
Yes. So when you go to count the lessers for count 2, they're together. Lessers for count 3 together. And lessers for count 4 together.
So as count 1, I read the lesser for second degree murder. Now these are the lessers for count 1 of manslaughter. And to prove the crime of manslaughter. Now in the middle, two elements beyond a reasonable doubt. 1, Nicholas Leonard is dead. And number 2, it says, give A, B, or C depending upon the allegations and proof. So A is intentionally committed an act or acts that caused the death of Nicholas Leonard. B is intentionally procured an act that will cause, I don't think he procured an act, did he? So B's out. And that it was caused by negligence. You guys are asking for A, right?
Yes.
Okay. So it's going to be just Adam Matos intentionally committed an act or acts that caused the death of Nicholas Leonard. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I previously instructed you.
Now, it does instruct me to add in justifiable homicide and excusable homicide from the introduction, so I'll just copy and paste that over.
What?
The explanations, on page 17, that paragraph says the explanations of justifiable homicide and excusable homicide are in the instruction.
But I just told them that, as I previously instructed you.
Okay, my bad. So
So I don't know why, I guess they're just trying to help the court because we're too dumb to realize that we read it earlier. I don't.
that's fine.
I've never reread them. I read them at the beginning, and I tell them as I previously instructed you. Now, I guess I could say, as I previously instructed you in the introduction, so that they know where to look for it? Or do you want just the way it's written?
And if I keep page numbers, I could reference the page.
So the question is whether or not we're going to repeat the instruction under manslaughter, the definition of justifiable homicide?
Right.
I'd like to include it again.
But you don't understand, the reason they put this paragraph in is because normally a manslaughter, well, I guess you would read the introduction to homicide, but I've never reread it. Why would I read it again? It's a page and a half long. Why would I, if I'm gonna read it, I'll just read it every time and not do an introduction. I could put, though, as I have previously instructed you on page 3.
And type just to justifiable homicide.
Right. Say it says either justifiable or excusable homicide. As I have previously instructed you on page 3, introduction to homicide.
I guess.
Not read it
Yeah, can we keep it with this? Let's keep the, can we keep the underlined language? That'll just,
again. No, you
don't want to do that?
No, but I can just say on page 3.
Yeah.
So in their instructions, it's on page 3 or whatever page, but I would assume it's going to stay on 3. So just say, see page 3, or I previously instructed you on page 3, period. So just put in somewhere, as I have previously instructed you on page 3, period. So they'll know exactly where to look for it if they can't remember what it was.
Can we put, okay, can you put introduction to homicide?
Sure.
No. Just do that, just so they really know. Okay.
Sure. There's nothing else on page 3 but introduction to homicide, but okay. That's all page 3 is. It's titled justifiable homicide and excusable homicide in big bold letters. But we wanna, that's what you want, that's what we'll give them. Can you do that, Chris?
I can.
Thank you. Let me know when you're done that, so we'll move on.
I'm ready. I'm
Okay.
just making notes and then I'll go back later and do it.
Each of us has a duty to act reasonable towards another. If there's a violation without any conscious intent to harm, that violation is negligent. So we're putting A in because that's what we're gonna read. So in order to convict manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only intent to commit an act that was not merely negligent, justifiable, or excusable, and which caused death. We'll take out cure, we take out culpable negligence. Take out the whole rest of that page, so we only have that very short paragraph at the top on page 18. Does everybody see where we are?
Yes.
Yes? Okay.
Yeah.
Then we're on to Megan. We'll do it exactly the same way. And then we're gonna fix the felon by carrying a firearm part.
Yep.
But we're calling it possession of a firearm and discharge causing death. We're taking out break. And then we'll make the same changes to the manslaughter. It'll be exactly counts 2, 3, and 4 will be exactly the same when we get to the changes that the state's going to make. We're going to be under 2A, and we're going to put in there that language about C page 3, introduction to homicide. So we can go on past accounts, all the lessers. We said how we want all of them to be the same. Plea of not guilty, reasonable doubt, burden of proof. It's the standard instruction. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it is overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence. The definition of reasonable doubt. It is to the evidence introduced to trial. Then the next paragraph, a reasonable doubt as to the guilt. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Any objection? And I'll probably say, when we get to this part, that these instructions apply to all 4 counts equally. We use these instructions individually to all 4 counts. We say it later, but I think I'd rather say it a little bit as many times as I can, so there's no question about it. Does the defense have any objection to that?
No.
All right, and I promise I'll just say that these instructions will be, you should use those individually as to each count going forward, but they all apply to the same. So then we get weighing the evidence. In weighing the evidence, I'm just gonna, my request is that we just go ahead and put them all in. That way, no one of, renumbering them, and then I have to make a decision whether, you impeached them enough, or whether, just have them all in there. They can make a decision based on that. So, we're just gonna read all 10,
Okay.
okay?
That's fine.
And then the next page on 34, the state has to meet its burden. The facts that the witness is employed by law enforcement, we want that one. Expert witness is in. Now, the question is, do you want him to leave in the defendant, in this case, become a witness for now?
Leave them both for the moment.
Right, that's fine. It's entirely proper for the lawyer to talk, and you may rely on your conclusion. So for right now, we'll leave both the defendant testifying and the defendant not testifying in. And then we'll have to make that decision. Now, there is a paragraph that says the defendant's statements. At this point, I have no post-Miranda statements. I have no statements to law enforcement. I know I have the Tampa Times interview, but that's going to be shown.
We intend on putting in statements, Judge.
Okay, so we're going to have this in. Okay, that's fine. That's why I didn't know if we were or weren't, so we're good. Okay, so that's in. Defendant's statements. Eyewitness identification. I'll leave it up to defense. You want it? All the way?
Yep.
Okay. I know we did photo packs, but sometimes the defense doesn't want this instruction even though it's photo pack. So, and this is the defendant's instruction, so I leave it up to them. So this is, we'll have the eyewitness identification instruction, then the rules for deliberation.
I took out the one that was the question,
Right. I would have had to take it out anyway.
experience with you.
Yeah, so normally there's 8, but we don't have any questions at this point, so there's no reason to have 7. It says only, if applicable. Now, the instruction says, and the state did it, but I want it on the record, normally in a jury trial, I read number 5 on the rules for deliberation says, your duty is to determine if the defendant has been proven guilty or not in accordance with the law. It is the judge's job to determine a proper sentence. However, in this case, it specifically says that when the jury is to be involved in a penalty phase, I think it should say if, but that's a whole nother story for another day. If they might be involved in a penalty phase, omit the second sentence. So he took it out. The second sentence usually says it's the judge's job to determine a proper sentence. So the instructions take it out when there is a possibility of a second phase. Does defense like it with it out, or do you, I think I have to take it out at this point. Because they put that down as a possibility. So,
I believe so.
so 5 will read, your duty is to determine if the defendant has been proven guilty or not in accordance with the law, period. Nothing about what my job is. All right, so we all agree to that. Then we have the cautionary instruction. And then you have the verdict.
And Judge, I have my objection to the second paragraph
Of the verdict?
of verdict. Yes.
Okay, so let's go through, there's 3 paragraphs normally on the verdict instruction. And this is 3.12, and it says, you may find the defendant guilty as charged in the indictment or guilty of lesser included crimes as the evidence may justify, or not guilty. You have no problem with that paragraph.
Correct.
Second paragraph says, if you return a verdict of guilty, it should be for the highest offense which has been proved beyond a reasonable doubt. If you find that no offense has been proved beyond a reasonable doubt, then of course your verdict must be not guilty. So what part don't you like?
The first sentence should be for the highest offense, eliminates the jury's pardon power. And I've objected to it ever since they added it.
Okay, so that'll be overruled, and your objection is noted. The third paragraph says the verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. And then it says each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. So there is a part where they could be found guilty of different lessers, but we don't have that problem in this case. So, we did have a mock verdict form, but it's not gonna work, because the state wants the aggravating lessers. And so that foresails longer verdict forms. Count 1 and 4 is fine. It'll just say, as charged, first degree murder, second degree murder, manslaughter, not guilty, and you guys want not guilty first. Defense is requesting that, the court is not going to do that. So counts 1 and 4, we have verdict forms. Counts 2 and 3, since we're giving them the interrogatories, we'll have to make the verdict form a little longer. Well, I just want the one. Just so you all know, I do this on a regular basis. When I have multiple victims on counts, I put the victim's name highlighted in the top. So it says count 1, murder in the first degree, and then in parentheses, it says as Margaret Brown. But actually, this is count 4. So it says count 4, and it says Margaret Brown. So that way, even though it says it in here, I want it easy for the jury to know when they're sitting down back there with 4, which one goes to which victim. And that way, if they decide to make different decisions as to each victim, they'll know it's not a problem for them. They clearly know that this one, when they work on it, is Margaret Brown. So that, I basically keep them, it says Margaret Brown in little bit over here, but I always put it highlighted in the top, just so you know. And I tell them that. So as to Megan Brown and Gregory Brown, we broke it down a little bit, but we'll finish up the instructions and then we'll go over the verdict form, because I'm not sure I like the book, that's fine. So then it's a single defendant, multiple counts or information.
I'll just take multiple counts.
Right, just put multiple counts. And it says a separate crime is charged as to each count of the indictment. And although they have been tried together, each crime and the evidence applicable to it must be considered separately in a separate verdict form returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as the other crimes charged, and then submitting the case to the jury is standard. The defense has provided a requested jury instruction. I guess you gave me 3 copies of the same one.
And I gave you mine too, so.
Okay, you want it back?
Yes.
Here, can you give that to me? And then if this goes to the state, if you have.
I have a copy.
I gave it.
All right, and for the record, the requested jury instruction number 1 says the fact that Adam Matos may have taken steps to conceal the bodies of Nicholas Leonard, Megan Brown, Gregory Brown, and Margaret Brown should not be considered by you as evidence that he killed Nicholas Leonard, Megan Brown, Gregory Brown, or Margaret Brown. And then you cite a case. All right, state, what do you say?
Well, Judge, I've, in between the going through of the instructions, I've been reading the Balzort case. And it appears as though there's some pretty strong factual differences between the Adam Matos case and the Balzort case. And those differences, I think, is really where the court should not allow this special instruction. The Balzort case is a case out of the second DCA where the cause of death was asphyxiation, based on the theory of the case that the defendant manually strangled his victims, and then they went to burn the victims in the woods. The analysis that I was able to read really references the Berube case out of the 6th Circuit, State of Florida, a case I'm pretty familiar with, that involves around whether or not asphyxiation or strangulation is sufficient evidence of premeditation by itself. And there was a lineage of cases discussed in Berube because it was tried a number of times, and I've had an opportunity to kind of see some of that history. And where the court in Berube said that there was enough to determine that asphyxiation or strangulation was enough to give premeditation, is that there was additional evidence of injury. And so in this case, it's the Matos cases, we have multiple forms of injury as to the victims. You have, as to count one, you've got blunt force trauma, 21 blows to the head. That is sufficient evidence to determine premeditation. As to count two, you've got a single gunshot wound to the left eye of Megan Brown. There is sufficient evidence to determine premeditation with a single gunshot wound to the face. As to count three, Gregory Brown, multiple gunshot wounds to the body with one of those into the hip area, and it's sufficient to determine premeditation. As to Margaret Brown, multiple blunt force trauma with a contributory factor of asphyxiation is sufficient, really in light of the way that she was bound and gagged and tied and hog-tied, for a jury to determine based on those injuries that there was premeditation. This case, this Balzor case, says that covering up the body should not, cannot by itself create a premeditation before, because it happens after. And again, it goes through the cases which outline where the cause of death itself is one that calls into question premeditation. Although I would disagree with the reviewing courts that strangulation is not premeditation. I can't imagine a more intimate hands on the neck of an individual squeezing till they die being a situation where someone would not want to cause the death of a person, but courts have disagreed with me in the past, and I respect their decision. But that being said, the evidence of cover-up in this case is different, and the cause and manner of death is different, and the evidence is sufficient to allow a jury to come to the decision of premeditation, and it really is the root of this case. Premeditation is discussed in count one as charged. It's also discussed in the lesser included, being the difference between murder one and murder two. I'd ask the court not to give this instruction because this case is just too far afield from the Matos case.
Thanks.
Kind of the reason why I'm doing it, Judge, is to tell them not to use concealment of the body as a basis for finding premeditation. Whether the facts of the case are sufficient, I mean, that is up to the jury. But this is basically a cautionary instruction saying that what happened to the bodies afterwards is not evidence of premeditation, which is what the case says.
That's not what your instruction says. It says, the fact that Adam Matos may have taken steps to conceal the bodies of the victims should not be considered by you as evidence that he killed them. Not that he killed them with premeditated design. I would assume that the state is going to argue consciousness of guilt to show that he was the murderer. Now, the level of murder, and I'm not even getting to whether I agree with if I put the word premeditated in there, but this case is all about whether the jury can use, or whether the argument can be made that obviously it was premeditated because he hit the body when he was done. If it was by accident, he would have called the cops, or he would have called an ambulance, or he would have, done something to assist her. But it doesn't say that they can't say that he hit the bodies because he's the murderer. I mean, obviously, they can argue that. So the question is, I'm not going to read the instruction that says if he hit the body, that means he didn't kill him, because they can use whatever they want to decide whether he's the person that committed the death. Because it says, first they got to convince you that somebody was killed, and then they got to convince you that the defendant did it. Then, after that, they got to decide whether it's first degree or second degree or manslaughter or excusable or justifiable. So the question is, obviously, if someone takes bodies and disposes of them in the woods, leaves them in the house and then puts them in the woods, which I assume is the defense, the theory of the state based on the testimony of how much it stunk by every witness in the world between September 1st and September 4th, they all testified, it was stinky, it was really stinky, it was a lot of stinky. That they're alleging that the bodies were remaining in the home, and at some point they were transported to be dumped. So my guess is that is going to show consciousness of guilt. Not that they were dumped so much, but that he had to get them out of the house because he couldn't bury them in the backyard.
Judge, so you do agree that perhaps if we amended to, it does not show premeditation, that might be an acceptable jury instruction?
I didn't say that. I said I'm not going to read this one.
Right, okay.
So the question is, are you asking me, so this one, as it's written, says evidence that he killed them. I'm going to deny that. So I'm going to write denied on here and sign it. And now the question is if whether you want to submit another one that's more in line to what you're trying to get me to agree to.
Yes.
But I haven't finished reading this case. So
Yes,
I'm going to sign this right now and deny it as written because I think that they can use the body placement as consciousness of guilt, or at least consciousness of trying to hide the actions. Let me just read it as to, so let me just finish reading this page real quick. Well, there's a big part in the middle of this case that's kind of bad for the defense, and it says,
Most everything is.
well, it says, in addition, the state did not present any other circumstantial evidence that suggests that Bolsard had a fully formed conscious purpose to kill the victim. Bolsard had not made any earlier statements that he was going to kill the victim, and there was no witnesses to the event, holding that premeditation was not proved, and noting that there was no suggestion that the defendant exhibited, mentioned, or even possessed an intent to kill the victim at any time prior to the actual homicide. I know it's been a while, but I'm thinking back to that 911 tape that was earlier on August 28th, where she said, he told me he was going to kill me. So obviously there's a significant difference that the state has provided to the jury an indication prior to the bodies being found or the death occurring, because the victim is being seen by law enforcement twice before she then no longer seen, and statements were made to law enforcement and have been presented to the jury that she says he said he's going to kill me, and I was scared, and I think he's going to kill me.
So they don't need the implication that the burial is a conscious of guilt, because they already have that. Why give them more?
Really? Have you been in this trial? Where is it about the bodies in this case? Because I'm reading it, I haven't yet found the body part.
You mean where he did with the body?
Yeah, where they said that they shouldn't allow the bodies.
I didn't read that.
I don't see anything about hiding the body here.
I read,
Mr. Livermore?
Quoting from Norton, I don't have the case, I just have an excerpt. State presented evidence that Balfour made efforts to conceal and burn the victim's body.
I'm sorry, sir.
I'm sorry. The state presented evidence that Balfour made efforts to conceal and burn the victim's body, but this evidence does not support an inference that he had the specific intent to kill the victim. I think it's around page 838. The fact that he may have taken steps to conceal evidence of a crime does not establish that he committed murder with a preconceived plan or design. Efforts to conceal evidence of a premeditated murder are likely to be as consistent with efforts to avoid prosecution for any unlawful killing, and that's the quote.
Okay, let me see, I think I found it in the middle here, hold on a second. Well, I've read the whole case twice, and the case doesn't say that, anything about reading an instruction to the jury. It doesn't say anything about the part that it was put in the woods. The only part of the fact that the body was set on fire was about the two broken, a tibia and she had two broken legs, or a leg broken in two places. I couldn't tell. And they said that they could not rule out the fact that that could have been done when they dumped the body in the woods before it was set on fire. So they were saying that those injuries, no witness testified that they occurred prior to her being set on fire. And so they were just saying those injuries themselves do not show premeditated design to get first-degree murder, because there was nobody to testify that they couldn't have happened when she was dumped in the woods and set on fire. They don't go to the actual way she was killed. Whereas the testimony in this case has been pretty consistent. The doctor can testify to exactly what was done when the murders occurred. There's really nothing that, nobody's testified that any of those injuries would have happened post-mortem. They all happened while they were, it's a single gunshot wound, it's at least another gunshot wound or two to Gregory Brown, and then the rest is significant blows to the head of both Nicholas Leonard and Margaret Brown. So not all of that shows that it was done during the act of the murder itself, and so I don't think the state's going to argue that the body being dumped shows indication of premeditation. State, are you arguing that?
No, Judge.
All right. So I don't think that I need to read an instruction, because I don't really think that the state one is going to argue that, nor I don't believe that the jury is going to find that from the instructions. The instructions are pretty clear that the premeditation should be determined in the act itself. So at this point, I've denied the instruction that has been requested. Is there any other instructions at this point that the defense wish the court to read, other than the self-defense instruction that you're going to work on and have for me tomorrow? Yes? Other than that, is there any other instruction?
Just to pick your brain, how about asphyxiation is not proof of premeditation?
That ain't happening. That's not what they say anyway. There's a lot of cases that say asphyxiation is proof of premeditation, depending on how it's done. Putting a bag over someone's head and taping it down, that would be premeditation in my mind. It's going to take a while for somebody to suffocate, as opposed to, the whole idea is that if you can, I think it's less than 70 seconds, that you can make somebody unconscious. So I'm kind of with the state. I don't know how strangulation isn't premeditated design, but I guess you got to go a little further than that. But in this particular case, it wasn't strangulation. It was with a bag over her head. So depending on how you argue that.
Thank you, Judge.
All right, anything else? Oh, I know what we need to go over. Closings. How much time do you think you need? State?
Judge, I would feel much better if this conversation was with Mr. Sarabia. I think he would benefit from the court's instruction on that more than I would.
And how much time do you think you're going to need?
I guess that would be dependent on Mrs. Sarabia's forecast as well, I think.
I've discussed it we discussed
2 hours?
No, Judge, we discussed it this weekend, so
So if I said no more than 2 hours, you're good with that?
I think we're.
I'm not saying you have to use that. I don't usually, as Mr. Kalis does, I don't usually have a rule of time. because I find that lawyers tend to use up every minute of time that I give them. If I give them no time, they end up just ending when they're ended. But in this particular case, I thought I'd go out there on a limb and say, okay, try not to use more than 2 hours, because if you go under that, the jury's not listening anyway. It's my suggestion, but I wasn't going to,
We discussed it yesterday, Judge, that we would keep it under 2 hours.
And again, please, no, you do not have to use all 2 hours. I'd be great if you didn't. But, and it'll be up to me to remind you of the time, not my clerk. I don't use my clerk to keep time, because I don't think that's what their job is. So I will keep it'll be a rough estimate. I usually write down what time each side starts and what time each side stops. If we have some sort of objection, I just kind of, I'm a little more soccer referee kind of person. I don't know exactly how much time, 5 extra minutes. I just kind of round it up and that, but I'm not going to say sit down, okay? So just know that I won't make either side sit down. I'll let you finish whatever part you're on, and then I'll have you sit down. But I'm hoping that neither side will use 2 hours. So just let Mr. Sarabia know that I did make a time, and I made it bigger than I thought you both needed.
All right. I will, there is a lot to discuss, but I will keep it, I will remind you.
Time to get succinct, put it in some sort of order. So, Spence, anything else that we need to discuss? All right, Mr. Matos, you've been here throughout. Everything good with you on those instructions?
Yes, Your Honor.
They're not really that complicated. We make them for everyday people. If you have any questions about them, please ask your lawyers about them. We won't be reading them until after the closing arguments, so it's, got plenty of time to talk over those with your lawyers. And I think because the state has indicated they might rest tomorrow, it's probably time that the defense and the defendant have a big, long talk about whether he wishes to testify, okay? I'll have this conversation with you multiple times prior to me making you make a decision or putting it on the record. I'm one of those people that try to wait until the very last minute, so that if you change your mind, I'm good with that, because it's not my decision to make, it's yours. So just know that until I have you stand up and swear and tell me what your decision is, you can change your mind multiple times between you and your lawyer, okay? So I'm not asking for your decision now. Even if I did, I'd ask you again later. But I think it's time in this journey that you're on, that you have a very long and hard discussion with your lawyers on what decision you want to make. Because ultimately, they can give you all the advice they want, but it's your decision, okay? And you can go against their advice if you wish, but you need to talk about that with them, okay? Anything bother you about the way they're proceeding? You're happy with their representation so far and their strategy in this matter?
Yes, sir.
Okay, great. We'll see you tomorrow morning at 9:30. I'm sorry?